Good afternoon, everyone. This is David Tashrudian from ADU1, and I'm here today to talk about ADUs and something particularly special, Senate Bill 9, SB9. So without further ado, let's get right into it. I'm going to share my screen now so we can discuss a PowerPoint presentation that I prepared. Let's see how do I do that? Here we are. Share, and let's get right into it. Okay, excellent. Helen's the pro. She does this every week. And so she knows a little bit better of how to share screens, but I think we're on. All right, so SB9 is a bill that is currently in the California State Legislature, and it provides for a couple of things. It provides for ministerial lot splits, and it provides for the ability to create duplexes, to build duplexes on single-family resident R1 lots, essentially lots that have been previously zoned for single-family residences. So let's talk about it a little bit. The current status of the bill is that it's enrolled. So if we go back a little bit here, you can see here that it was passed by the State Assembly on August 26th, 2021. And then it went to the State Senate. It was passed on August 30th, 2021. And now you see here, it's in enrolled status as of September 1, 2021. So what happens when a bill is in enrolled status is that it goes to, and I'm not sure who it really goes to, but it goes somewhere into the abyss for final verification and proofreading to ensure that the bill that's presented to the governor for signature is in fact the bill that was passed by the Senate and the bill that was passed by the Assembly. So right now the bill is being proofread for accuracy and will eventually get to the governor's desk. What's kind of funky though is we're not really sure who the governor is going to be. We're not sure if it's going to be Governor Newsom or somebody else, but our hope is, and my hope is, that whoever the governor is, that the governor will appreciate the fact that we need more housing in this state, and Senate bill is a real easy way to incentivize the construction of new housing. So let's talk about what is Senate Bill 9, Senate Bill 9, SB9. And forgive me, I have a small cold. My son brought it over from school. It's not COVID. I got tested, so bear with me in case I'm a little nasally or if I have to cough once or twice. So a couple of key highlights of this bill is that it requires a city or a county to ministerially approve either or both of the following, right? And A is a housing development of no more than 2 units, essentially a duplex, in a single family zone. That's a lot that's zoned R1. And then 2, the subdivision of a parcel zoned for residential use into 2 approximately equal parcels. And that's sort of defined in the statute. So essentially, what SB9 is doing is it's letting you take any previously zoned R1 lot and putting a duplex and allowing you to put a duplex with 2 houses, 2 units on that R1 lot. So essentially, the R1 zoning will now disappear. It'll also allow you to subdivide a parcel zoned for residential use into 2 equal parcels. I think this is great, and it provides a real opportunity for people or investors that have large lots, like a 10,000 square foot lot, for example. So take that lot, subdivide it into 2 lots, and create essentially 2 R1 parcels. And we'll talk about how you can maximize and get the highest and best use out of those 2 parcels in a little bit. So with respect to the lot split, and we're at a property here in Reseda, with respect to a lot split, the lot split has to be ministerially approved. So the lot split procedure doesn't have to go through a hearing like it had to previously. It must be approved in a very ministerial fashion, which is essentially it. So long as The proposed lot split complies with all of the rules in SB9 and the government code here. You can see 66.411.7, which is the proposed added government code section. So long as the proposed lot split complies with all of those requirements, the city is required to stamp and approve the lot split. Now, with respect to the lot split can create no more than 2 new parcels. So you'll take a parcel and create 2 new parcels, and one parcel cannot be smaller than 40% of the total lot area of the original parcel. So in other words, if you have a 10,000 square foot lot, you can split that lot into 2 parcels, one that's 6,000 square feet and another that's 4,000 square feet, or a lot that's or split that 10,000 square foot lot into 2 5,000 square foot lots. What we're looking at here on the left is a property that's currently for sale in Reseda. It's 8731 Strathern Street in Reseda, California. The reason I wanted to take a look at this lot is you can see that this lot is perfect for the lot split, because you can take the first half of the lot and split it from the second half of the lot and create a new separately R1 zoned lot in the back. And it looks like both of these lots can be split such that each split lot is 5,000 square feet, and which is perfect to build a house or a duplex. So this is essentially a breakdown and an overview of the requirements. Subsection A here talks about how you have the 40% rule, that the one split lot cannot be less than 40% of the total original parcel. And then there's also a minimum square footage. So you have to provide at least 1,200 square feet minimum for the split lots, unless the city or county adopts a smaller minimum lot size by ordinance. But it's likely that the cities are going to adopt the state rule, and you won't be able to split a lot into into 2 lots that are smaller than 1,200 square feet. Which, in any event, that would mean that you're taking a 2,400 square foot lot and you're splitting it into 1,200 square feet each. So another restriction is that the parcel cannot contain an existing rent-restricted structure. That's subsection C here. And then subsection E is stating that you can't split a lot if you've already split an adjacent lot. So you got to be very mindful of that. The state doesn't want speculators running around splitting lots in a neighborhood and then selling them off and creating essentially unaffordable housing. So the biggest takeaway here is the 40% lot area of the original parcel for the smaller lot, and then the minimum 1,200 square foot parcel. There is another requirement here. A local agency may require that the owner sign an affidavit stating that the applicant or the owner intends to occupy one of the housing units in the split lot as their primary residence for a minimum of 3 years from the date of the approval of the lot split. So let's say, for example, in this 10,000 square foot lot that we have, we're splitting it into 2. The owner may, depending on the city, excuse me, have to sign an affidavit and swear that the owner will be living in one of those lots for a minimum of 3 years. Another rule is that the urban lot split has to be in an urbanized area and cluster. So here we're taking a look at all of the urbanized areas in the state of city of Los Angeles, state of California. The urbanized areas and cluster map is based on the 2010 census. You can get this map from the US Census websites. And essentially all of the area inside the green outline, so you can see here pretty much all of Santa Clarita Valley, up here, the Northern Valley, a lot of the West Valley, not really much of Ventura here, but most of Los Angeles, Long Beach, many parts of Orange County, and the Inland Empire are all in the urbanized area. So lots in the urbanized area are allowed to be lot split. Lots outside of the urbanized area are not. So if you're looking to purchase a lot and split it into two, uh, I would consult this map to determine whether or not your lot or the proposed lot is within an urbanized area. And here are some of the other prohibitions that are contained in the statute. One of the prohibitions that really stands out to me is if the lot is within an earthquake fault zone. So you also want to determine whether or not the lot is in such a fault zone, and you can do that here. So, so I provided a link to a map that's published by the state of California, and you can enter an address, and the address will sort of pop up like it does here on the left and let you know whether or not the parcel is within a fault zone. So you see that here, fault zone. This parcel is not within the fault zone. This is the Strathern property that we're talking about. So really, if you've got all the tools at your disposal, you can go onto the census's website to determine whether or not a proposed property or a property that you own is in an urbanized area. You can also go and check whether or not it's in a fault zone. Another interesting aspect of the proposed lot split and duplex aspects of SB9 is that when you do add a new unit, you may not be required to provide additional parking, just like the ADU rule, so long as the parcel is located within 1/2 mile walking distance of a high quality transit corridor or a major transit stop. And you can, and pretty much any parcel in the city of Los Angeles complies with that. You're within a 1/2 mile walking distance of a high quality transit corridor or a major transit stop. So you will likely not have to provide replacement parking. Okay, so that's the end of the slideshow, and we'll come back here, and I will take that away and come on back. So what does this mean? So essentially what SB9 means for property owners is that they can take a single lot and turn it into 2 lots where you'll have up to 4 units at least, at the very least. So you'll take one lot, for example, we're talking about the 10,000 square foot lot, for example, and we can split that into 2 5,000 square foot lots and put 2 duplexes onto each lot. Now, the law gets a little bit funnier because you're also entitled by right to put an ADU onto each of those lots. However, SB9 does have a provision in there that's saying that the state, or the city rather, has the right to prohibit the construction of an ADU on a lot split. So you might not be able to do that in some cities, and some other cities you may have the right. So technically, you could put up to 6 units on a single family previously R1 zone lot, 2 on the front lot, for example, and 2 on the back lot. Now, we had the Strathern example up. Let me see if I can bring that up for us again. Let's share this again. Let's come back. We can talk about that lot a little bit more in depth. It's a Strathern parcel. You can see that the house in the front is taking up pretty much all of the lot, and you've got the lot in the back. What you can do is provide an access, ingress and egress easement on this lot to allow access into the back. So the parcel in the front would be the subservient tenement, and the one in the back would be the dominant tenement, allowing for the people in the back to use an easement on the driveway here, the driveway side here, to access their home in the back. So you're essentially creating a flag lot, and by doing so, you create those 2 lots with the 4 units. So you take a single-family home and turn it into 4-plex. Nothing like this has ever been proposed in the state or allowed. So I'm hopeful that the state will allow, the governor will sign the bill into law and allow this innovative and really unprecedented way for people to get the highest and best use out of their property. So that's pretty much all I have to say about SB9. It's really a high level overview. Essentially, what we're going to do is take one lot, split it into two, build two houses on each lot. All of a sudden, you take a single family home and turn it into a fourplex. I've got the chat open, and I was hoping that people had questions. And if you do have questions, you can type it into the chat. Or if you wanted to talk about a particular property that you have, you can give me the address in the chat here, and we can discuss. If no one out there in the internet has a question for me, I might just end here a little early. We're right at 12:46. We've been on for about 15 minutes, and considering that I got a small cough and it's not easy to stay on for very long, I might just end here. And it looks like that's what we'll do. So if you do have any questions, you see our telephone number here, 866 new ADU1. You got Helen's email address, helen@adu-1.com. We've also got our website's address, apartmentadu.com. You can reach us through any of those avenues, and we can talk about adding ADUs to your multifamily property, to the single family property, and seeing whether or not your property is a good candidate for a lot split under SB9. So with that, I'll leave everyone out in cyberspace, and I wish you guys all a good day, and we'll talk soon. Thank you. Bye-bye.